had a couple questions, if that's okay.
Go ahead.
I'll start with the most important one. I was wondering, has anyone ever taken a CPS court case off record?
Hey, this is Attorney Vince Davis. This is The Secret, How to Fight CPS and Win. I'm here with my co-hosts, Brian Hamilton and Aaron Carranza. So, I think we lost Lucinda on the phone. So let's
She's
take
back.
Oh, you're back, Lucinda?
Yes, sir.
Okay. We're going to take a quick call here to end this hour. We're going to talk to Cassie from Yuba City in California. Cassie, did you have a story to tell or a question to ask?
I had a couple questions, if that's okay.
Go ahead.
I'll start with the most important one. I was wondering, has anyone ever taken a CPS court case off record? Has a judge ever done that?
What do you mean off record?
Well, a few weeks ago, me and my husband were in a CPS court case, and the attorneys were arguing, and the judge took the entire hearing off record.
I don't understand what you mean by off record.
Like
She destroyed
you know how
the app.
people document it?
You mean
Yeah.
with the court reporter?
Yeah, it was taken off of that. The court reporter stopped typing.
Yeah, I've seen judges do that before, or attorneys asked to go off the record.
Is that normal?
I wouldn't say it's normal, but it's not impossible.
Is it legal?
Yes, it is. In California, it is.
Oh, okay. And then I guess another question I have is, I'm involved in two CPS cases, one in Nevada County and one in Sutter County. And I was wondering, one county is trying to reunify my husband and I with our children, and the other county is trying to break us up.
Is it regarding the same children?
No, it's regarding a different child in the Nevada County case and his children in the Sutter County case.
Well, wait a minute. Are the parents the same in both cases?
No,
Are you a parent in both cases?
I'm a parent in both cases.
What you should do is talk to your attorney in the most favorable county to you, and ask him or her to make a motion to consolidate those cases.
Okay.
Because it's
That's a
very
good idea.
it's very unusual for you to have to fight in two different counties, the same or similar allegations, right? One county could find you, quote unquote, not guilty, and the other county could find you, quote, guilty. So you could have conflicting court findings, which is not supposed to happen at any time. That's why it might be good to consolidate those cases together, even though they're in different counties.
Okay. And then I guess I was going to ask, has anybody who has abused a child actually reunified with that child?
Say that again?
Has people out there like that have actually literally hit their child and became a felon over it actually been able to reunify with that child?
Brian, what do you think?
Yeah, it actually is pretty. It's pretty common, and that's somewhat unfortunate because the people who have been found guilty of actually abusing their children are at really high risk for recidivism. And in fact, a lot of the kids who have been victims of, who've been victims of abuse and have died, have been ones that have been reported previously for abuse. And so it is an issue, and one that kind of comes up because of the fact that CPS is often trying to keep families together. So if they've completed their requirements and so forth, they can actually be reunited with the child.
Cassie, in California, at the end of the disposition hearing, the judge will make a determination on whether you will be given family reunification services. And in almost every case, there are some cases, though, that are, serious or heinous or whatever, you will be given family reunification services. And in those cases which you're not, you can always appeal it or take what's called a special writ. But even if you've, hit your child and you were ordered to have family reunification services, that's the plan, that's the goal, that's what the judge has ordered. So as long as you work your plan, you or whatever parent it is can try to get the child back, or can, try to get visitation, overnights and stuff with the child. Does that make sense?
It does. It wasn't me that hurt my kid. It was the other one.
The other parent?
Yeah, the other parent. And I was also wondering, is it legal for CPS to defy court orders, such as visitation and moving forward in a case?
No, it's not. Lucinda, what do you think about that?
It's contempt of court, and you bring it to the judge.
So if the judge doesn't do anything when it was brought to them?
I don't know about you, Vincent, but I always try to get a new judge.
Well, I hear you, Lucinda, but Cassie, what I'm going to tell you is very important. Sometimes you bring it to the judge. That doesn't mean that you brought it the right way. You have to file a motion for contempt.
Yeah.
You just can't walk into the court. Yeah, you just can't walk into the court and say, "Hey, judge, I'm not getting my visitation." And the judge, most judges will probably, look at you like, "Okay, and what do you want me to do?" Because you haven't made any official request. You haven't come forward with any competent evidence. I've been involved in cases where the parent has said, "I'm not getting visitation." And the social worker says, "Yes, you are. You're getting all your court-ordered visitation." Well, that's a dispute of a material fact. What the judge is going to have to decide, right? But you can't do that unless there's some type of hearing or motion. Like Lucinda said, maybe it's called the same thing in her state, but in California, it's called an OSC Ray contempt, order to show cause regarding contempt. You can file that motion at any time. Now, believe me, there's some substantive and procedural requirements to filing that motion. And if you're a civilian with no legal training, I wouldn't try to do it myself. In California, you have a court-appointed attorney, or you have a private attorney that you've hired. You should ask her or him to file that motion for you. Now, sometimes
they don't?
Well, that's the $64 question. I tell people all the time, get your attorney to do A, B, and C, and they call me back and say, my attorney won't do it. That's an interesting question depending on the circumstances, but I bet Lucinda has an answer for us. Lucinda, what if your attorney doesn't do it?
You get them debarred.
Okay, what Lucinda is referring to is you make a complaint with the state bar of your state in California. It'd be the state bar of California, right?
Okay. And then I guess another question is, can CPS tell you to terminate your relationship with your significant other? Otherwise, they're not going to reunify you with your kid?
They can if they're sex offenders. They absolutely can.
They tried to see
my
my ex-husband.
It depends on the reason whether or not they can do that.
Cassie, in California, it's my humble opinion that they can never do that. Do they do it? All the time.
Yep.
They did it in my case.
Do I complain about it? It depends. It depends on whether it's going to help my client or hurt my client and what my client wants. Sometimes my client wants to get out of the relationship, and she or he uses that as the excuse. Sometimes I have a case right now where they're telling my client that, and he doesn't want to leave his wife. Right? So,
yeah,
we fight for the other way. The whole goal in California is family reunification services. Theoretically, no matter what has happened.
I've had cases where I had the parents go ahead and get a divorce and separate until they get the children back and their case closed. And then I tell them to move to another state and just don't get married, move in together. I've had them do that. Just don't tell me what state you're moving to.
Yeah, I guess what's happening is in my Nevada County case, they're telling me that I need to terminate my relationship with my significant other because he actually stopped my daughter, but he has gotten help since with therapy, medication. He's taking a 52-week child abuser class. He's on probation, and he's following all of the rules. He's in therapy till this day, and it's been 3 years. And they didn't take her when we first got back to California. They kept her in my custody. Even the courthouse kept her in my custody, knowing that he did it. I admitted it on record. And now they're trying to use that as an excuse not to reunify me with my daughter. And they're saying that I haven't made behavior changes because I haven't.
Casey, we have to take a break. I'm sorry. My engineer is getting ready to cut us off. We're at the top of the hour. Thank you for calling in. Thank you for listening. Call us back in about 2 or 3 weeks. Let us know what's going on with your case. This is The Secret, How to Fight CPS and Win. We'll be back after this news break and commercials.